I am the clerk, and I will welcome the members of the court. All rise. The Honorable, the Chief Justice, and the Associate Justices of the Supreme Court of the United States. Oh yes, oh yes, oh yes. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, so we'll hear argument first this afternoon, case number 11-1425, Missouri v. McNeely. Counselor, thank you.
Justices, this is a case about reasonableness. This question that's asked of us is whether it is reasonable to require someone to have a Fourth Amendment search warrant prior to drawing a drunk driver's blood. In this case, it was reasonable because the drunk driver, while he drove, committed a crime that affects each and every one of us almost every day. More drunk drivers kill people than guns in the United States every single year. While we can search a home for drugs or a person's car for a gun without a search warrant, we cannot take a person's blood, a simple blood draw, without a search warrant under the ruling of Missouri.
Counselor, why is the blood alcohol content obtained from these blood draws a uniquely necessary piece of evidence in order to convict somebody for this crime?
Because in order to convict someone from a crime, their blood level or their blood alcohol content has to be above 0.08.
Right, I understand that, but why is the evidence gathered specifically from the blood draw necessary to convict? Is this a unique piece of evidence that the state needs?
It's not unique. There's two primary pieces of evidence from which the state can obtain a 0.08 or greater alcohol content. The first piece of evidence from which they can attain it is a breath test. A breath test is a specifically measured instrument that a person blows into, and it measures their breath content. If the person refuses to blow, there's no way to obtain that other than a blood draw. Does that make sense?
Yeah, absolutely. Counselor, are there not punishments for refusing a breathalyzer in most states?
In some states, yes. In the state of Idaho, for instance, there is no punishment because petitioners in the state of Idaho, persons who are accused of that crime, have done what is an argument of the petitioner, in this case, us. They've agreed as a condition of driving that when they get their driver's license, if they're pulled over for a driving offense, that they've essentially created a contract between the state and themselves. That driving is a privilege and not a right. And as a result of being a privilege, they have to provide a blood sample if they refuse to take a breath test. And the reason for this is because in the past...
Counselor, in the state of Missouri, though, if somebody refuses to take a breathalyzer test, their license is revoked for a year. I mean, we're talking about Missouri. I understand social contract theory, but if their license is revoked, whatever, or I mean, regardless of whether or not they provide this or not, how does this entail with the case at hand?
Well, this is a good question, because with the social contract theory, as it is in this, well, in the state of Idaho, which I'm familiar with, under the social contract theory, my argument is much broader. The concept that the driving is a privilege rather than a right means when a person takes upon themselves the privilege of being able to drive, that privilege carries less of a right than, say, for instance, a person who's secure inside their house with the windows drawn and the blinds closed. They walk outside their house.
Counsel, why does the state need blood tests now? Haven't we been persecuting drunk drivers for, I don't know, forever, essentially? At least as long as the highways have been around.
Persecution is, the state would disagree with this term from the justice. Persecution is hardly something from which the state could be contested for draining someone's blood. It's not like the British invading people's homes prior to the Revolution, the American Revolution, which is a primary reason for the Fourth Amendment. Persecution would be slamming into somebody with your car while drunk.
Since we're talking about reasonableness, how reasonable is it for us to look at other states, and why not decide this on a case-by-case basis? And without having to forego the warrant requirement altogether.
A case-by-case basis would exist in whatever state we looked at. If we looked at everything on a case-by-case basis, we'd be in exactly the same situation we're in now, where this court faces the opportunity to make case law based on this case. If we look, for instance, at Schmerber v. California, that's case law that was based by this court in the past. So, in response to your question, yes, we should look at things on a case-by-case basis, but it also helps us if we look at what everybody else is thinking in the United States. Well, we don't stick our finger out, lick it, and try and get the...
Counselor, so I guess getting to, one of the big issues that personally I see in this case, I don't know if anybody else does, but the condition or exigency of the issue, I guess, where do you draw the line of when an exigent circumstance exists in this case?
Well, I think that the Justice's prior question is accurate. We draw the line based on fact-specific findings. You do not have before you a case that's anything other than fact-specific. Just as the court, when they were in Schmerber, didn't have a case that was anything other than fact-specific. You can't take the facts of this case and try and predict in the future what it will lead to. You try.
Okay, but in the facts of this case specifically, there is a time delay that is set for the issue of if you wait for a warrant, obviously there is a time delay and evidence may be destroyed. But I guess how do you respond to the issue that this time delay is intrinsic almost to the process of getting a warrant or applying for a warrant or trying to get a warrant for this?
Well, the time delay obviously would destroy the state's evidence. Say, for instance, someone blew .09.
But I'm saying not necessarily that it's the state's fault, but that there is intrinsically in the process to get a warrant issues with a time delay. You have to ask for somebody else's approval to get a warrant. And so I guess, where do you stand on, I guess, in relation to having to wait for going to the hospital, wait for the warrant in any way, shape, or form? What, I guess, deadline do you put on the waiting that will help us clarify a minimum time requirement for what you're advocating? Like, what do you want us to limit it at to preserve evidence?
As soon as possible.
So
and
if
both good.
I'm sorry. If the issue at hand is a time delay, should the police be able to administer warrantless blood draws on the side of the road rather than taking the time that it would be necessary to transport an individual to a hospital?
And if there's going to be a time delay anyways, to get to the hospital, going on and seeing the crime scene, why should you use that time to get a warrant?
Okay, working backwards, your question. In some states, that's allowable. The officer at the point of arrest can then transport the person either directly to the hospital or to the police station for a breath test. In this case, the same thing happened. The police officer has got the person under arrest. He's in the back of the patrol car. As they're driving towards the police station, he says, I'm not going to take the breath test. Police officer just turns.
Counselor, I want to go back to the start of the case before we get too far along. You're claiming that exigent circumstances of the facts of this case created a waiver for demanding a warrant to get the blood test, and that the exigent circumstances justify the officer's actions. How are you proving exigency if the officer didn't try to get a warrant in the first place? I mean, he said that in the past 10 years or so he's been doing this, he hasn't had an issue before, and he testified that he didn't think he'd have an issue in this case. So how is there exigency if you haven't even tried to get a warrant?
Well, the thing that changed in this case is that just prior to the police officer doing this, it was always required in the state of Missouri that he get a search warrant. And the holding in the prior cases was that this was like a benefit, because as you know, states can have a higher standard than the Fourth Amendment in the federal level. That's the baseline. In the state of Missouri, it was higher. Then they deleted the portion which the officer thought, okay, in this case, I don't have to take him anymore. So it was a new exception. He wasn't relying on the previous things.
If I'm mistaken, I think that the warrant, I mean, it's always best to get a warrant. I don't think that the Fourth Amendment baseline is that you can get blood samples without first procuring a warrant.
Well, that's what the Fourth Amendment tells us. And that's what our Fourth Amendment case law tells us, is that it's always best to get a warrant. But there are several cases that say we don't have to. Stop and search
Counselor,
the car.
while we're discussing that, I'd like to backpedal. You mentioned case law and that this court has a chance to uphold case law that would be used. I'm curious how you reconcile the idea of us upholding case law with the idea of exigency, which you then argue should be on a case-by-case basis. What sort of case law are you looking for us to uphold in regards to exigency?
Well, I'm asking you to uphold Schmerber v. California, based on your interpretation of it. Not only that, but this court, while it follows precedent, sets its own.
Sure, but Schmerber was a careful examination of the facts, correct, Counselor?
Correct.
Should that not occur in every case?
Yes.
Wouldn't a ruling for the petitioner ultimately mean that we no longer need to look to the circumstances of exigency? Wouldn't we just be assuming that exigency exists because they probably couldn't get a warrant or the delay would be too significant?
Well, there would be certain cases that the Supreme Courts in other states would simply say, yeah, this fits with the United States Supreme Court's ruling. And then it would be petitioned to you, and you'd say, no, we've already dealt with that, and you'd reverse it, and it would just go back to the courts. That would be it.
But, Counselor, the circumstances in this case you're claiming provide exigency or are in every case involving alcohol. I mean, the liver naturally dissipates alcohol in the bloodstream. That's in every DUI case. And if we grant that as allowing sufficient exigency to void a warrant requirement, then in every DUI case we're going to be having warrantless blood samples. Am I correct in this, or is this
it would
not
be possible
permissible?
to have a, as you say, warrantless blood sample taken. But in the same respect, yes, we're asking that every single time a police officer has probable cause. We're not saying every time we find someone, we're just going to grab them, stick a needle in them.
And Counselor, what constitutes probable cause for the state?
Probable cause in this case, and probable cause in most cases, as DUI investigations are conducted, is the driving pattern. He doesn't have a good driving pattern. Gives the officer cause to believe, hey, maybe this guy's driving under the influence. Then he takes him out, he does a horizontal gaze nystagmus test. Based on that test, the guy
Counselor,
fails.
why not just
And
have...
the other test, that gives him probable cause.
Why not just force them to take a breathalyzer test? Is the Fourth Amendment so inexclusive as to allow the state to take blood but not to force the device in front of someone's face?
Do you mean why not force them to take the breathalyzer test? The problem is the person doesn't have to blow. And you can't knock them on the back until the air comes out. And it's a very specific instrument. You have to blow a certain amount before it actually makes the reading. So if they refuse, you can't do anything to suck it out of them.
Counselor, so if we were supposed to rule for you, wouldn't we be setting a bad example for the states to be more inefficient? Wouldn't it incentivize them to be more inefficient? Because if you're going to say this is going to be case by case, there's just going to be like, they're not even going to try to get a warrant. So why should we reward them? And second of all, according to your logic, the blood sample argument apply to other situations, such as underage drinking or public drinking and stuff like that, or is this specific to DUI? I just want to know the breadth of where you're going with this.
Underage drinking.
And stuff like that.
And that's a good question. To start in reverse, let's say that someone is under the influence of drugs and they're just walking down the street. It wouldn't apply, and there's two reasons why it wouldn't apply. One, a person walking down the street under the influence of drugs isn't something that at that point the society cares about enough that it rises to the level of not only exigent circumstances, but also the danger it poses to the community. This is a public policy argument primarily. We're asking this court to protect the lives of citizens across the country.
But what if said individual that was high on drugs happened to have a concealed weapon? Like, there's still, I mean, different
Well, again,
circumstances would allow for a similar application of this ruling in other cases, is what I assume Justice Kagan is trying to get at.
Well, applying the law to the facts of that case, well, we can imagine a case where you'd have to revisit this issue again. A person who's carrying a concealed weapon, who's under the influence of drugs in public, the officer's going to stop and do what we call a Terry stop. Then they're going to pat it down. They're going to feel the weapon. Still no need to search him for drugs.
Counselor?
In some cases, children or mothers have babies, and there are blood draws, and the baby's test positive for meth. There are blood draws that are allowed for that if the hospital takes it.
Back to the sobriety field tests that are conducted by officers. Several states do not allow warrantless blood draws as of currently. Are there any records of lower conviction rates for DUIs in states that do not allow warrantless blood sampling?
I do not know. But I would say this. It is okay for a state to require a higher level than this court sets. If this court says, look, you don't have to have a Fourth Amendment warrant in order to draw someone's blood, the states can still say, you know what, we want it to be higher. And yes, we do want it. And then the officers would have to get a Fourth Amendment warrant.
Counselor, you begin to frame this as an issue of public safety. Do you believe that the police officers currently lack the necessary legal powers to detain a suspect who may be drunk?
They can't detain the person. It's not the issue. And they will detain the person. They'll detain the person
Then my
for a long
question
time.
then becomes, I still don't understand where you're gaining this idea of exigency.
But
Why
exigency
is a DUI a uniquely necessary exigent circumstance to circumvent a warrant requirement?
Because a DUI is like a person in a house flushing drugs down the toilet. And this court has held that when that's happening, the officer's outside and can hear it, they can bust into the
But
house.
the distinction in that case,
Counselor?
the distinction in that case is specifically that when you're flushing drugs down a toilet, it's a now or never kind of thing if you don't
Exactly.
interrupt then. But with alcohol, as we understand as a court and have previously understood in decisions, it's not a now or never thing. It gradually decreases at a consistent rate, but it does not go away immediately. So it's not a now or never qualification.
It is an hour and ever qualification because if the person is at .084, within 15 to 30 minutes, it's gone.
Counselor, however, evidence would still exist regarding failed sobriety tests that could be used in a trial conviction,
But
correct?
the very best piece of evidence would be the blood draw.
But
Not
Counselor,
only,
is
fair,
there-
not only fair for the state, but imagine a person who fails the field sobriety test who's actually under .08.
Counselor, where does the Constitution guarantee the state the right to access the best evidence in a way that triumphs in a way that's paramount to the considerations afforded to the individual by the Constitution?
Exactly. There is no right, but in this case, there is an exigent circumstance. There's no right for the states to do whatever they want. This is a fact-specific, specific scenario case where just because we say they can, the police can want to get into your house all they want. They can want to get your body all they want. But we don't let, what we need is probable cause and reasonableness. And I'm
Counselor, you
arguing that
compared
this
this
state's probable
to,
cause and
Counselor,
reasonableness.
you compare this to cases in which people are flushing drugs down the toilet and willfully destroying evidence to avoid conviction. How do you consider this equatable with the natural function of the liver dissipating alcohol in the bloodstream? These seem like two categorically different issues. Somebody who's dissipating alcohol in their bloodstream is doing so unconsciously without a motivation to avoid conviction, and they're doing so at a predictable rate that can be retroactively estimated. I don't see how you're comparing this and how this is aiding to your exigency.
Well, because the person isn't convicted for trying to flush the drugs down the toilet any more than they're convicted for letting the alcohol dissipate in the body.
Yes,
The
but
thing that's
if we're
important-
making an exception to the Fourth Amendment based on the fact that the blood dissipating in their blood, or the alcohol dissipating in their bloodstream is destroying evidence. If we're creating this exception to them, aren't we creating an exception for them, their body functioning naturally? I mean, why should their Fourth Amendment warrant requirement be avoided because of that?
Because the effects are the same, the loss of evidence. And it doesn't matter
Is
whether
there,
they're doing it willingly or not. The loss of evidence is what matters to the state.
Counselor, is there any reason that the petitioner could not have gotten a warrant in a timely manner? As I understand it, a warrant can sometimes be procured in a half hour, and the petitioner argues it can take up to 2 hours, but why could the officer not have called, found out if he could get a warrant in under a half hour, and made his decision from there?
On average 2 hours. And you're right, search warrants can be attained faster. But whether they can be attained faster or not isn't the issue, as we stated in our brief. That's only
Counsel, I believe that's the issue of exigency here, as the court understands it.
the issue of exigency exists right at the moment. But to say, well, you could have gotten it sooner rather than later, doesn't allow for the time period that can happen in most cases, 2 hours.
Going back to Justice Roberts' question, though, wouldn't this prove some sort of exigency if you were applying for a warrant and unable to get it in a certain amount of time? Wouldn't that at least demonstrate that there were exigent circumstances that would have prevented the officer from collecting blood before they could obtain the warrant?
That would prove our case. The question itself proves our case.
How so?
Well, you're saying that if we go to the trouble of getting a warrant, and then the blood dissipates to the point, the blood alcohol content dissipates to the point that it's no longer good.
I'm saying if you start the process of getting a warrant, and then within 30 or 45 minutes, if some sort of exigent bright line was established, in 30 or 45 minutes, if the warrant was unobtainable, or the estimation was going to be that it was going to take up to 2 hours, and then a blood alcohol sample was taken with a blood draw, wouldn't that provide a reasonable bright line for the exigent circumstance?
So-
This court's extremely hesitant to grant a case law categorical ruling that says that an exigent circumstance exists in every single case because you might not be able to get a warrant in some jurisdictions.
This is interesting because you're going to do the same thing this court could do this. You're going to do the same thing as established in Miranda v. Arizona, where this court set certain precedents that a person has to be warned of prior to being questioned, right?
But this case is completely different from Miranda rights and the fact that you're forcing somebody to go through a relatively invasive procedure. I mean, I'm terrified of needles.
I know that the
think that's
facts,
an invasive procedure.
bear with me, it's an analogy. Because what he's saying is, you could say, look, we want you to try and get a search warrant. But if 30 to 35 minutes have gone by and you haven't been able to get it, then okay, now you can draw blood. Is this what you're saying?
I believe it's a consideration the court should make, absolutely.
But
So you
even-
could say 30 minutes have gone by, then it's okay to draw blood.
Counsel,
So
you
should
did not try to obtain a warrant in this case. I don't see how this is pertinent. How do you establish, you're assuming that there's this 2 hour, like that it would have taken 2 hours to get a warrant in this case, but you never even the officer didn't pursue a warrant to begin with. So this goes back to my previous question. How do you know that because taking a warrant would take so long that it would prove exigent circumstances when you didn't try to get a warrant in the first place?
The exigent circumstances, like I was trying to say before, which I misstated, the exigent circumstances isn't the fact that it would take time to get a warrant. The exigent circumstance is the blood itself, the alcohol content inside is dissipated.
Yes, and related to that is the time it would take a warrant to get the blood sample with the warrant within the Fourth Amendment. Yes. Am I right?
I'm sorry, I'm not understanding the question.
Yes. Alcohol naturally dissipates in the bloodstream at a particular rate of time. You didn't seek a warrant because you believe that taking a warrant would take so long that the blood would dissipate to the point that the evidence would be destroyed. Am I correct? Is that your argument?
Yes.
Yes. And you're saying that the fact that it would have taken so long to obtain the warrant would have mean that the evidence would have been destroyed? Yes.
Yes.
And that's where the
Yes.
proof of your exigency
Thank you.
comes from.
But you never tried to obtain a warrant, petitioner. Your officer never tried to, and therefore I don't see where exigency exists if you're not trying to go through the actual constitutional pathway of obtaining it. I don't understand where this exigency is coming from.
Well, as the court keeps saying, I think I understand your argument, that the state should try prior to obtaining the search warrant. The problem with that is we try, then there is no try really in the probable cause realm. There is do or do not. And if we try, then the judge says
The
yes
officer
or no.
never tried to get a warrant in the past?
Once we try, if this court requires that we have to get a search warrant in order to do these searches, then the officer shows up in front of the judge, presents probable cause, and the judge says yes or no. And at that point it's done. If the judge says no, you can't draw the person's blood. If the judge says yes, then you go back and you draw the person's
I'm
blood.
familiar with this.
So,
There is no try. Only do. It's
Okay,
one or the
even
other. Does that make
kind of
sense?
beat the try issue, even if you had attempted to apply for a warrant in this case, I guess I'm still not seeing where you are proving exigency in that even if there is a time delay of 2 hours to get a warrant and you use blood sample and use other means of testing like retroactive measurements, whatever it's called, I don't remember exactly, but you can retroactively test the blood at the time that you take it to assume or measure what it would be at the time of you pulling over this, or the officer pulling over an intoxicated person. So I guess why...
The problem with retroactive measurements is that they're guesstimates, 1.5 to 2.0, but they're dependent on the person's body weight, height, whether or not they've eaten, all those things.
And
make a
just to
difference.
clarify-
We wouldn't be sure if the person were actually under the influence. We want to do it right now.
To clarify, retrograde blood extrapolation analysis is very controversial and it's under fire in a lot of jurisdictions, is it not?
Correct. Justice Ginsburg, to go back to your question, essentially we're arguing that as soon as possible the test should be taken in order that the state could do it. We are arguing that we don't want to apply for a search warrant. And the reason is we feel like it's just that by this point we have so much probable cause that, and then if we don't, we can be overturned later.
Counselor, if you want to get, if the issue is getting, if the warrant's not taking, is taking too long, why don't you expedite your process of obtaining a warrant instead of trying to expedite, all of the different things you have to go through and all the different protections in order to get a blood sample?
Because justices, as you know, like their sleep. And waking a judge up in the middle of the night is never.
Counselor, the failure of the state to provide a speedy warrant process is not reason to persuade this court that we should circumvent the protections afforded by the Fourth Amendment of the Constitution.
Well, the exigent circumstances of the blood alcohol content dissipate warrant this requirement.
What about other less invasive procedures or less controversial procedures or usages of like urine sample? Or if you can encourage somebody to give a breathalyzer by saying, I'm taking you to the hospital, you're gonna have blood drawn, do you wanna try this again? Will you take this breathalyzer? Like other means by which to use less invasive procedures to still get that accurate ruling.
Well, before I rest, because I have 10 minutes left, urine sample, I'm not sure that you can measure a person's breath or blood alcohol content in a urine sample. But we have to force the
I
same
think you
thing.
can from what
Even if
I've
we
legally
do, we
read.
have to force the person to pee or stand there and wait with the cup. And maybe more invasive because you're dealing with the person's genitals.
what makes the blood sample so unique, or what's the sui generis of this?
Because everything that we're doing leads to the blood alcohol content of a person. It's the gold standard, considered by many of the people in the field to be the absolute best test of where a person's actual blood alcohol content is. I'll reserve the remainder of my time.
Thank you, Counselor.
Thank you.
Madam Chief Justice, may it please the court. The issue in this case is whether the police can compel a warrantless blood test in every driving while intoxicated case, even when the special facts that this court identified in Schmerber are missing, and even when there is no reason to believe that a search warrant could not be obtained in a timely fashion.
Counsel, looking into Schmerber, excuse the pronunciation, I understand from the facts of the case that a blood test is undergone after a drunk driver had crashed on the side of the road and was found unconscious. Should the state have to wait for so long and to wait for so much damage just to wait for a warrantless blood sample?
It's my understanding that it is this court's reasoning that the reason that exigent circumstances were present in the Schmerber versus California case is that, as the justice has identified, Mr. Schmerber, going home from a tavern, coming home from a bowling alley, approximately midnight, ran his car into a tree, and both he and his companion in the car were injured, and so the police had to respond. They had to, as police do in accident cases, they had to determine and do an investigation of the wreck, and then they had to transport both Mr. Schmerber and his companion to the hospital. And so 2 hours plus had transpired since the time the police made contact, and clearly the dissipation of blood alcohol and the time that the clock was ticking, they did not feel after 2 hours that there was time to secure a warrant and to do. And so in this court held in that situation, because there were conditions beyond the police's control that caused there to be a delay.
So like a crash
There
or
was a
other
crash.
societal damage.
Correct.
Are you stating that you're comfortable with a, say, 2-hour bright line as to when the police could withdraw a warrantless blood sample?
No, I'm not comfortable.
But that was one of the considerations in Schmerber, was it not?
It was. It so happened that that is how long it took, because they were investigating the accident. They had transported the individuals to the hospital. But I don't believe that it had to do, and certainly the respondent is uncomfortable stating that there is a time limit. What we are comfortable with is there not being a categorical waiver of the Fourth Amendment every time a person steps into their vehicle.
So should we approach this as the court then on a more jurisdictional by jurisdictional basis, considering the fact that certain jurisdictions, due to their rural proximity, are less likely to be able to issue a speedy warrant? Is that something that you as a respondent would feel comfortable with?
The respondent would feel comfortable with there being a case-by-case analysis in each of these cases, regardless of
Counsel,
where.
what would a case-by-case analysis look like? And excuse me if I'm not entirely familiar with how DUI proceedings may or may not go, but I mean, a suspect fails a field sobriety test, they've been seen going over the speed limit. What kind of value would a magistrate actually add in here? Is there anything that an officer wouldn't be able to assess on the scene?
What would the value of having an impartial tribunal review the police's observations?
I fail to see how an individual responding with information that could easily be done on a check mark via an electronic warrant can be all that much better than an officer just simply doing it at the time being. Particularly so when blood alcohol loses at an ever constant and serious rate.
I would submit to the court that it is a foundation of our Fourth Amendment jurisdictional history in this country, that there may be a perception that a magistrate judge who is called in the middle of the night by an officer from the scene and is going through a checklist is merely rubber stamping the officer's observations. I think we have to have more faith in our judicial system than that, in the belief that the magistrate takes their role very seriously. They are fielding that phone call in the middle of the night. They are asking questions of the officer, and it is a foundation of our Fourth Amendment jurisprudence that we have an impartial magistrate review the decision of the person who was on the ground.
Given the fact that so many states have this checklist in order to procure a warrant in DUI cases, what level of protection can these warrants actually afford an individual when it is so easy to obtain these warrants?
Again, Your Honor, I would say that we have to have faith in our magistrates across this land. They are taking their job seriously, and although there are certain steps that have been taken to make this process more streamlined and to direct officers in the field in what can be a very chaotic situation to sort of go down the list and have the specific information that they provide to a magistrate, we do have to trust that our magistrate is not merely rubber stamping the information, but is listening to that information, looking for the probable cause that they feel would justify a warrant.
What makes this qualitatively different than a breathalyzer test? I mean, we can allow those without a warrant, and they seem to undergo without Fourth Amendment protections here. I fail to see much of a distinction.
Well, the case that's before us today has to do with blood draws, and certainly as a respondent, I think that there is a valid question as to whether or not it is permissible under the Fourth Amendment to force and compel an individual to take a breathalyzer test. I think the distinction that a petitioner would draw is that certainly, I think most of us would agree that blowing into a balloon or blowing into a device to test the blood alcohol content of your breath is far less intrusive than the facts of this case, in which somebody was handcuffed with their hand behind their back, restrained by 2 orderlies at a hospital, and forcibly punctured with a needle.
And in this specific case, the the individual was offered the breathalyzer twice and refused it. Does that not then diminish the unreasonableness of the police searching to procure another option?
The respondent's position that, Justice Alito, is that Missouri does have an implied consent law, which is that if you agree to have a driver's license, you are impliedly consenting to having your blood tested either by breath or by blood. You also are able under that law to withdraw your consent. The remedy to the state, if you withdraw your consent, is that they suspend your license for a year. And so,
in my understanding,
Counselor,
Missouri law.
going off of that, a breathalyzer and a blood draw are significantly different in their degrees of intrusiveness. You said that we should call into question whether or not breathalyzers should be obtainable without a warrant. Is that logic you'd like to uphold before the court today?
I think that it's not a question before this court. If you were to ask me my personal opinion, and yes, I believe that it is a question this court should consider.
So would our holding not demonstrate in case law our belief in that logic used to justify your case?
I'm sorry, I didn't follow you.
Would our upholding, were we to rule in favor of the respondent, using logic such as that, calling into questions things such as that, not be reason for us to discuss breathalyzers in the future?
I think that if this court wants to go into that question, which is not before the court, you are certainly welcome to do that, but it's not my understanding that the court typically addresses questions not before it. We do not have the question of breathalyzers before the court today.
Yes, Counselor, that's true.
Counselor, referring to blood tests specifically, it makes sense with the Fourth Amendment protection against unreasonable search and seizure. In an individual's home, they must protect their personal effects from the view of the state. What specifically is being protected when we prevent the state from obtaining a blood test? What's so valid about protecting from that?
This court has a long and storied history of protecting not only one's sanctity of one's home, but also the sanctity of one's body. This court has, in the Terry style discussion that you had with the petitioner, certainly allowed that if a police officer believes that someone may be concealing a weapon, that they can pat down that individual.
So it's a reasonable argument, right? Basically, the reasonable expectation of privacy of one's body versus one's home, and that applies here because it's the body and the blood samples being taken, right?
It is absolutely having to do with what is being protected is the right not to have the state.
Then the problem I have with this kind of argument is how would this affect our proceedings with the application of the totality of the circumstances test? For example, we have identified one of it, right? Which is the emergency of the vehicle going off the road, so that causes the delay and all stuff like that, right? And how many more of these can we identify? And this is going to cause immense confusion for the court. How do you respond to that?
I apologize, Justice Kagan. I'm not entirely sure I follow your question.
So basically, we're saying that the emergency created in Schmerber, that the car ran off the road, and so and so facts and case specific, created the exigency, right?
Yes.
So how many of these would we have to identify if we take up your logic in order to apply the totality of the circumstances test?
I think that I'm not asking the courts to establish any bright lines. I am simply asking this court to continue to say that the law of the land is that we must make these decisions on a case-by-case, on a totality of the circumstances, and we are trusting the judiciary at all lower levels throughout the nation to consider all of the factors. If we were to accept petitioner's position, we would simply be stripping away any question. It would be a per se rule.
Counselor, I'd like to draw your attention to some of the petitioner's arguments and how it relates to our judicial history. We have many cases that talk about the destruction of evidence as being an exigent circumstance. How do you reconcile the petitioner's argument that this active destruction of evidence is occurring when the liver metabolizes alcohol that's currently in the system?
Well, there is a long history in this court having to do with the destruction of evidence, and that the exigent circumstances exception.
Why is this not one of those cases?
This is not one of those cases because in the state of Missouri, as is required, or as is the status in all 50 states in this country, there is the definition that Mr. McNeely was arrested on and convicted of. It was Missouri's annotated statute 577.010, and it says a person commits the crime of, quote, driving while intoxicated if he operates a motor vehicle while in an intoxicated or drug condition, period. There is no mention in that statute of a blood alcohol content. And so, there is no deprivation to the state by not having...
Yes, Counselor, but isn't blood alcohol content, as the petitioner claims, a critical piece of evidence, regardless whether it's obtained through a breathalyzer or blood test, in convicting a driver of driving under the influence?
It is strong evidence. It is the best evidence, but the Fourth Amendment does not give the state permission to seek the best evidence against its citizens.
I think, going back to my original question in regards to the judicial history, I think we have found exceptions to this when evidence is being destroyed. How do you reconcile the fact that evidence is being destroyed by the body?
I reconcile it by a number of factors. In this present case, Mr. McNeely was pulled over. He was taken out. The officer observed a driving pattern. The officer observed that he had glassy and glossy eyes.
I think we're aware of the facts of the case, but I think the distinction that could be drawn from this is that, repeat what you said before.
Why is this not considered a case of destruction of evidence when the active metabolizing of ethyl glutamate, which is the enzyme of alcohol in its process used to analyze blood alcohol content, why is that not considered a destruction of evidence in the same way the court considers flushing drugs down the toilet a destruction of evidence? And we have created exceptions and granted cases of exigency for warrantless searches with these cases.
A lot of the exceptions we have created have been in cases in which it's been purposeful, correct? And this is not a purposeful destruction of evidence. And so it's not necessarily...
Justice Roberts, I'd like to hear counsel's response to my question.
I would... my response to you, Justice Sotomayor, is that the exigent circumstances as it pertains to destruction of evidence, taking, for instance, a drug case. If the police is standing outside of the door and they hear...
But what about this case, Counselor?
Well, I have to wrap it all up in the sense that there is a now or never exception to... we believe that there should be a now or never component of the exigency. Blood alcohol, as the court is well aware from all of the briefing, is dissipating at a 0.02 per hour. So in this instance, Mr. McNeely, there was a period of time, and the state could have, by its own admission, obtained a warrant within 2 hours, and ultimately, with the proof of this blood test, he had a 0.15. If it had taken the 2 hours that the state themselves says it would have taken to obtain a warrant, he would have been down to a 0.11.
Counselor, petitioner notes that the variation in blood alcohol dissipation depends greatly on height, weight, and also the aptitude of drinking of the individual. And petitioner notes that blood alcohol content can actually be decreased per hour by 0.08%. How do you respond to the fact that dissipation is not the constant 0.02 that you tried to present before the court?
I'm not a scientist, Your Honor, so I'm not familiar with and I'm sure that it is hotly debated in all of our courts and in the many, many DUI cases that our courts see on an annual basis, and I would simply defer to the scientists in the tribunals to figure that out.
Counselor, absent a blood draw or a blood sample, what evidence can the state present in order to get a conviction for a driver driving under the influence of alcohol?
I'm glad you asked that question. It is where I was headed. In this case, the state of Missouri had a very, very strong case against Mr. McNeely, even absent any blood testing. They had a driving pattern. They had observations of his having glassy eyes. They could smell the blood alcohol, or they could smell alcohol in his breath. They required him to do the FSTs, which are very extensively researched, and there's much debate and scientific evidence presented in courts about the efficacy of those FSTs, the field sobriety tests, and they did not, the state of Missouri, particularly under the statute, which does not require a blood alcohol content to convict someone, could have, and in many cases in the past, and many times in this nation, people are convicted all the time of DUI without submitting to a blood alcohol.
Counselor, what is the advantage of having an independent judge issuing the warrant versus losing a drunk driver who has the potential of killing people? Where do you weigh the benefits and costs? Why would you say that is more important than the interest of the state, which is legitimate in controlling DUI cases?
Yeah, it is a hard position to stand in front of this court and defend drunk driving, and certainly I hope the court does not interpret the respondent as being in support of drunk driving or not believing that drunk driving is a horrible condition that is a plague and causes many deaths in this land. That said, there are many crimes in this country that we could solve much more easily. It would be far simpler and far more efficient for our police to investigate anywhere they wanted to go, and to go into any house and to do anything that they wanted without a warrant. And we have decided as a nation from our very founding that it is preferable, as odious as it might be, to allow some people to not be charged and not be convicted of crimes, but to protect overall our right to be free from warrantless searches and seizures.
Many states do require a specific BAC level before conviction can occur within a DUI case. Because blood alcohol does decrease over time, do defendants have a vested interest in delaying the ability of the police to receive a blood sample?
I would say that if you are an experienced drunk driver and you've been through the system before and you've spoken with your wily defense counsel and they have told you that yes, it may be in your benefit to delay doing a test.
Would this not mean that there are exigent circumstances?
I think that the response to that would be if law enforcement knows in a case-by-case basis that someone is purposely trying to thwart the system and prevent them from achieving evidence, that it would be appropriate for to run that by a magistrate and have the magistrate agree.
Counselor, in this case, wasn't the defendant, was he not someone who had been convicted of drunk driving several times before? I believe that was in the brief.
He had been convicted twice before, and quite frankly, I believe that is why, and this is pure speculation on my part, that the officer was so zealous in wanting to get a blood draw from him.
But you just said that would create exigent circumstances.
That's the point. I think I believe my position is that if you believe as an officer that someone is trying to thwart your efforts, that you should then take that information to a magistrate and have the magistrate agree or disagree with you.
Is it reasonable to force a police officer to watch the destruction of evidence in hopes that they could eventually procure a warrant? Because as we know, in certain jurisdictions, such as rural jurisdictions, or in this specific case in Missouri, it could have taken up to 2 hours to receive a warrant. Are you suggesting that it is legitimate and a legitimate interest of the state to force an officer to watch the destruction of evidence?
I don't believe that there is any reason for the officer to wait to watch the destruction of evidence.
So should the officer be unable to obtain a speedy warrant, meaning that they would be forced to therefore watch the destruction of evidence, what do you suggest is a valid bright line for the officer to therefore secure the evidence?
I think that this court has issued in Schmerber versus California pretty clear direction to the police, to our law enforcement community, that if there are situations beyond the officer's control, as in that case where there was an accident investigation, a transport to the hospital, a passage of time.
A situation beyond control could in fact be the inability of a magistrate to grant a warrant, under your own logic, correct?
It is, and if you're in, I mean, what we don't want to do is to encourage jurisdictions to get lazy and to simply say to law enforcement, oh, by the way, if it's middle of the night, you call, you can't get them, or you wake the judge up and he's kind of sleepy and he says, I'll get to you in the morning, that's good, you just kind of stop.
But it's an indisputable
Counselor-
fact that certain jurisdictions, such as rural jurisdictions, have a less number of magistrates than, say, New York City do on hand.
Counselor
Does that
Dean-
not, in and of itself, explain the exigency in this case due to the fact of the inability of the police to efficiently contact and maintain a warrant from a magistrate?
I agree, Your Honor, but I think that what I would ask in that case is that when that defendant goes to court for the first time, they have the right to file a suppression on the evidence, to have that question addressed by the magistrate hearing the DUI case to determine whether exigency actually was present.
Counselor, do you believe the state's failure to provide sufficient judicial infrastructure to provide a speedy warrant is a reason that we should circumvent the protections of the Fourth Amendment?
I do not. I think that it is, we should not be rewarding the law enforcement branch of our system with the inefficiencies of the judicial side.
Counselor, do you think it's meaningful that the court in Smurber didn't just stop at the fact that alcohol was dissipating in the defendant's bloodstream, that they included the delay, the circumstances that are unique to that case and not pertinent here?
I think it's very significant that they applied the special facts, and I think that the debate across this country and in all of our state Supreme Courts where this issue has risen it boils down to the interpretation that each court makes of the language that this court concluded their statement in Smurber. In Smurber, obviously, this court upheld a warrantless blood draw, and so some state Supreme Courts view that to mean that this court says that they are permissible, while the other courts point to your other language which says, based on these special facts alone, it is permissible, but they are not. You are not making a broad statement that it is permissible in all cases.
To clarify, Counselor, your position is then that if an exigent circumstance can prove to exist, it's okay for a warrantless blood draw, but the court should refrain from making a categorical ruling. Is that your position?
Exactly. I think this court should upheld your decision in Smurber, which is exactly what you just stated.
So if the court was to determine some new special fact classification that could in fact include a bright line of a specific amount of time, would that therefore satisfy your position that Smurber would be upheld?
I apologize, Justice Alito, but you...
In order for us to, I say, avoid a per se ruling, would you support a ruling that had the special fact classification included, so insofar as there was a time determination included in those special facts?
The respondent would be more comfortable leaving it to the discretion of the lower courts and the courts at the ground level who have these cases come before them to be presented all of the specific facts in their case and make a determination. I think that this court has been reticent in the past to sort of layer bright line after bright line after bright line and provide a number of rules, but instead has deferred historically to allowing the judiciary to hear the facts, present before them, and make a totality of circumstances fine.
In Kentucky v. King last year, this court overwhelmingly ruled that the destruction of evidence in and of itself provides for exigency. How then do you negate petitioner standing that the destruction of BAC in and of itself could be considered a special fact classification under Smurber?
I think that there's a great distinction between the destruction of all evidence and destruction of some evidence. And in the situation of a DUI stop, an individual cannot be pulled over unless the police officer has reasonable cause that some crime has been committed either, and it's typically a pretense if they swerved over the line or they had a brake light out or they had some traffic infraction which then allows them to make contact. And then they have their personal observations of the defendant. They oftentimes administer the FSTs, and they have a body of evidence that they can present to a jury to get a conviction. I do not believe that there are many cases that have been proven and defendants convicted without a blood alcohol. And so the destruction of evidence distinction that I see is where if that evidence is destroyed, the case, the state has no case. If you flush drugs down the toilet, there is no case for the state.
Excuse me, but wouldn't the same facts be the same? You had probable cause in which you'd like to search the house. Wouldn't that be the same in this situation where you have probable cause, a man's been swerving on the road, he's going over the speed limit? I fail to see a distinction between the absolute certainty that alcohol will dissipate through the liver, and an inability for a toilet to may or may not flush a certain amount of drugs down its water stream.
What would,
The police would still need probable cause for someone to be flushing heroin down the toilet. You don't just walk willy-nilly into someone's home for the same reason you don't just willy-nilly pull someone over on the side of the road and decide that you need to pull their blood to test for DUI.
the distinction I would make is that in flushing the heroin down the toilet scenario, that case is going to end up at your entry-level tribunal, and that there's certainly going to be a motion to suppress based on a warrantless search. And this court has not said, in all blanket instances, if a police officer has reasonable cause to think something hinky is going on inside a house, they can just barge in. They do have to then demonstrate by a totality of circumstances that exigent circumstances existed, and in this case, we're going to strip away with that. We're going to say you have probable cause to believe somebody committed DUIs, exigent circumstances exist. Boom, you don't have to go and argue about it on a totality of circumstance basis, and that is what we object to.
Counselor, in Kentucky v. King, officers simply heard movement on the inside before they entered the home to search for drugs, and the court upheld the fact that that in and of itself was justification for the police to enter the home and search for drugs. If the police already have a standard of reasonableness, i.e. the roadside testing and also a smell of alcohol on a breath, would that not fall then into the logic of Kentucky v. King?
I think it goes back to our position that these decisions by the police need to be reviewed by a court, either in advance in the course of securing a warrant, or the ability to successfully, without being just kind of cut out at the knees by a decision by this court saying, in all cases, exigent circumstances exist in a DUI stop. And so I think the distinction there is that there would be a considerable amount of litigation in the situation where an officer hears something behind the door and they go to a court, and ultimately they'd have to go to a court, they'd have to explain it, and then magistrate or district court.
From your position so far, I feel as though you're saying that petitioner's exigent circumstances in this case actually exist. Is that what you're saying?
In this case?
Yeah.
We do not believe exigent circumstances existed in this case because, as per the officer's own testimony, he had secured warrants in the past, knew how to do it, knew there was a prosecutor on call, knew there was a judge on call, said he'd done it many times in the past and it took him on average 2 hours to do it. And if he had followed that procedure, gotten a warrant and conducted the test, gotten a warrant to do the blood draw, he would have, even with the 2 hours elapsing, gotten the evidence that would ultimately convict Mr. McNeely.
So to be
Counselor,
clear,
is it your position that a ruling by this court in favor of the petitioner would be taken by the lower courts to understand that there is always an exigent circumstance in the case where the officer reasonably believes that a DUI has occurred?
Absolutely.
to be clear, under your all or nothing standard that you presented during testimony, the only way that an exigent circumstance could exist regarding the destruction of evidence is if the entirety of the evidence is destroyed. Am I correct?
I think that is the underlying, yes, I think that that's the underlying.
Counselor, is it possible to destroy the results of a field sobriety test?
Is it possible? Not to be crass, but I suppose a bullet to the head of the officer.
Is it possible to contest it, that a person is just poor on balance?
Excuse me?
Is it possible to contest the results, that a man is just poor on balance without the additional evidence that a BAC test would provide?
It is, yes, there is much litigation and contesting of the validity of field sobriety tests.
Thank you, Counsel.
And Counselor, what about the validity of the officer smelling, for example, alcohol in the breath? Is that a piece of evidence that can be destroyed absent, as you so crassly put it, a bullet to the head?
No.
Thank you.
Should we therefore rely on officers to have the most shaky of evidence or the most contestable of evidence, wherein we could in fact provide for the best evidence, which would be the BAEC standard?
I'm sorry, I don't follow that question, Justice Liddell.
At the point where field sobriety tests can be contested, as well as individual officer testimony can be contested, if we can provide for evidence that is incontestable, the BAC standard, why then does the state not have a legitimate interest in providing for that level of evidence?
The state certainly has a legitimate interest in obtaining the best evidence they can. The Fourth Amendment does not grant the government the right to secure the best evidence against its citizens, as convenient as it would be for our law enforcement and prosecutorial brethren to do that.
Thank you.
Thank you very much.
You have 6.5 minutes.
The focus in this case has been on exigent circumstances, but it should be on probable cause. This is not a case merely about exigent circumstances. That's only one factor among a factor of many: the field sobriety test, the driving pattern. Now, the officer has probable cause to believe that they should take a blood alcohol content level if the person doesn't provide a breath sample. It's not that the state, in response to Justice Sotomayor's questions, which are very pointed and well taken, by the way, but it's not that the state should just have the ability, how much evidence is available. The question is whether the state has probable cause and whether it's reasonable for the state to take it.
Isn't the distinction between probable cause and requiring a warrant specifically on cases of the invasive nature of whatever procedure is being used? Like the fact that a blood sample being taken is more invasive than specifically a breathalyzer test or a urine test or a field sobriety test, and those lower invasive ones only require probable cause, but because of the invasiveness of the specific test, there is a higher standard for it.
Invasiveness has been a factor that the courts have considered, but primarily they've thought about exigent circumstances. A car is mobile, so even if the officer just has probable cause to believe that they can search a car for drugs, the Supreme Court said they can. A house where drugs are being flushed down the toilet, the Supreme Court said they can. Even if it's just people moving around inside the house. I mean, that's much less. Now we know that the blood alcohol content is being dissipated. So to answer your question, yes, the invasion is a factor, but so are the totality of the circumstances. That would be one, but exigent circumstances would be the other.
Counselor, how do you resolve the differences in these drug cases, the all or nothing standard that the respondent puts forward? In these cases, when all drugs are destroyed, there's no way to collect evidence yet. The respondent claims that you can't destroy the results of a field sobriety test, nor can you completely dismantle the credibility of an officer who says that he smells alcohol, meaning wouldn't there be some evidence remaining?
Let's say this, as a prosecutor, I could find somebody guilty just based on the field sobriety test that if they'd blown, might have blown under .08. So the question here isn't whether or not we can prove it with the field sobriety test. The question is, what is fair? Is it fair? Is there probable cause to believe that this person's blood should be taken? And based on the totality of the circumstances, if the answer is yes, then the officer can draw their blood because it's an exigent circumstance.
So, Counselor, are you now arguing that drawing blood is in the best interest of the defendant?
It could be. It's in the best interest of the state. We're not trying to create a case to persecute a person, which was the earlier question by Justice Scalia. We're just in search of the truth. Is it probable? Does it fit within the Fourth Amendment? Not that we're skirting around.
Do you truly believe that this search for the truth, that he's sticking a needle in someone's arm, is a reasonable is that circumvention of the Fourth Amendment protection truly reasonable?
It's not a circumvention, Your Honor.
That invasive?
We're arguing that it's not a circumvention. It's the third time Your Honor your Justice has said that, but it's not a circumvention. It's a drive right through the middle, because right in the middle of the Fourth Amendment says probable cause and reasonableness. The officer has probable cause to search a car when they think drugs are inside. This court's have no problem with that.
Counselor.
Probable cause to think the person's under the influence and they can search the person for blood alcohol content, the state also argues should be upheld.
Back to Justice Alito's question from earlier from our first discussion. Would those states that allow a roadside blood test then be allowed to test any car that they suspected of drunk driving on the side of the road as a non-medical professional to stick a needle in that person's arm?
No, a medical professional has to take the test, and that's the holding in previous cases. We're not
But what if
arguing
that
an officer
provided
to
for
do it.
less of a delay or more accurate readings? Because that seems to be what you're arguing for, is we want to get the best evidence, more accurate readings on the blood alcohol level. And if allowing police officers on the side of the road to administer these blood sample tests, would you advocate that?
If they could do it, that would be the state's position. I mean, if it were medically sanitary, if they could prove that the way they drew the blood, that would be the best place to take it.
So doesn't petitioners...
But they also have to have the field sobriety test, they'd also have to have the walk and turn, the whole thing, they'd have to have it, the breath. I mean, they're not just looking at the walk and turn test, there's breath, there's blood in their eyes, there's slurred speech, the eyes are glassy and bloodshot. If that were the case, then
Counselor,
yes,
now
right
you've
there would be
confused
good.
me. Are you now advocating for a medical professional to do these blood draws categorically, or
No, in fact, in some jurisdictions, including Nampa City, they draw it themselves because they're qualified phlebotomists.
The officer.
So if
Okay,
an officer
isn't-
could become a qualified phlebotomist, they could do it.
Isn't a lot of the petitioner's argument in the case brief about how it's not as invasive because the procedure is taking place in a hospital, that's why it's a reasonable search? If these cases are allowed to be, or if these tests are allowed to take place on the side of the road by a police officer, doesn't that make it less of a reasonable search and more of a violation of the Fourth Amendment?
For starters, the presence of an EO makes me squeamish, but this court has held that it's painless.
When done by a medical professional?
But would not phlebotomy training for officers, such as in the example that you indicated, would they not be therefore able to draw blood as effectively and as painlessly as a medical professional in a hospital?
You have answered Justice Kennedy's question.
Counselor?
Wouldn't you say it's reasonable to assume that a suspect of drunk driving, knowing that an officer of the law could easily, without haste, take his blood sample, that we'd have more consents to breathalyzer tests on the road?
Because they talked to Wiley Defense Counsel, we'd have less. And then the other problem is we would punish the good, people who blow into the tube, but we would let the bad drive home. Someone who said, nope, I'm not going to blow, then they waited, then we let those people continue to drive. But someone who's a good, upstanding citizen who blows into the breath tube, they get punished. That's not fair.
Do good, upstanding citizens normally drive drunk?
Yes, good people commit all kinds of crimes. People are good at heart, they commit crimes.
Counselor, do officers searching your home without a warrant cause pain? Or your car? Because we're talking here about how we've ruled that drawing blood is painless, but I'm not seeing how pain is the deciding factor of the warrant protection.
Well, I think
it seems that the invasive nature of the procedure is the issue and not whether or not it's painful.
The invasive nature of the procedure is the issue.
Counselor, do you not find it counterintuitive that a ruling for your
Or is part of the issue.
for the petitioner would create a circumstance categorically in which exigency existed when the entirety of the decision based on the exigency clause was one that said we should examine on a case-by-case basis? Does that not strike you as...
Well, you can say that in your opinion. You can say we should examine it on a
Probably will,
case-by-case basis. But what this court has argued about case-by-case continues to come up. But what you'll provide, no matter what you do in this case, will be guidance for the entire country. Police officers will know what they can or cannot do.
Thank you, Counselor.
Thank you.
And I'd like to thank our two attorneys and you guys. So.